We are going to begin with Introduction to Contracts. We will break it down as we go along here in this first part of the course. Before we jump in, though, I want to remind you, you probably saw it on the syllabus, but just to remind you, you can in the reading material, you can disregard the materials on what you see as the CISG, or the Convention on Contracts for International Sales. We are not going to be discussing that in class. It's not a topic on the CPA, and it's beyond the scope of this course. So, I mean, certainly if you want to read it, but you're not going to be responsible for knowing about it or what it is. Okay, so without further ado, contracts. Contract rules, they provide the foundation of many of the topics that we are going to discuss this semester. Mortgages are based on contracts. They are contracts. Your checks or negotiable instruments are based on contracts. Establishing partnerships based on contracts. So we are going to see the concept of contracts throughout the course of this course, So we'll get a good understanding of this material, and we can move forward here. So contracts fall under two areas. There's two categories of contracts. We can find contract law under our common law, and we can find contract rules under statutory law, or the Uniform Commercial Code. The common law contract rules apply to contracts that are not a sale of goods. For instance, what would be something that's not a sale of good? If you're going to be an accountant and somebody's going to come and pay you, they're paying you for your service. So that's a service. And that's a contract that falls under our common law. Real estate, insurance, if you hire someone to clean your house, that's a type of contract that falls under the common law. The other set of contract rules are found under Article 2 of the Uniform Commercial Code, and that governs transactions involving the sale of goods or the lease of goods, i.e. like tangible property. So a contract involving the purchase of a vehicle, or maybe purchasing carpeting for your house, or if you buy a piano, and if you buy items on Amazon.com. Those all fall under, those types of transactions are sale of goods, which are governed by the Uniform Commercial Code. So for every contract question you're faced, you have to determine what set of rules are going to apply and what does the transaction involved. So what is a contract? What is a contract? What's the definition of a contract? How do we define it? The law likes to define it as an exchange relationship created by oral or written agreement between two or more persons, containing at least one promise and recognized in law as enforceable. So consider this. If you hire me to shovel your driveway and you pay me $20, is that a contract? Looking at our definition, we have a oral discussion. We have more than one person. We have two in this case. And we have promises. We have at least one promise. I promise to shovel your driveway, and you promise to give me $20. We have two promises in that case. And if one of us doesn't do what we're supposed to do, I shovel the driveway, and then you don't pay me $20, I can enforce that. So, before we jump to accountability, I want to go back to this list. Voluntary, oral, or written agreement. So we have to have an agreement, or shoveling the driveway. That's oral. We can also document that on a piece of paper. But we have to both be consensual to that. You can't force me to shovel your driveway. You can't threaten me to shovel your driveway. And we have to have that between the two of us. Okay? Exchange relationship. People who bind themselves to each other for a common purpose. Okay? If you go and have your hair done, you're going to pay your hairdresser to cut your hair. Okay? Even a barter. You don't even have to have money involved. You can have a barter exchange. Maybe you make a deal with your hairdresser where she cuts your hair and you walk her dog. That's a relationship. You don't have to have money exchanged. It could be barter. And you have to have at least one promise. Somebody promises to do something. And in that case that we've been using, me shoveling your driveway or your hairdresser, that's an exchange. Each person promises. Hairdresser promises to cut your hair. You promise to walk the dog. I promise to shovel your driveway. You promise to pay me $20. And then enforceability. It has to be enforceable. Like I said earlier, you have to be able to sue somebody in court. And the dinner invitation, a commitment to go to the movies, politicians' campaign promises, you can't, and then they don't come through with their promises, you can't sue the politicians. You promise your parents to clean out the attic and you don't. No, you need a legal obligations. Maybe those are moral or ethical, but not legal. So those items are not enforceable by law, so that would not be deemed a contract. Okay, accountability. How do we know that someone agreed to a contract or to specific terms? How do we know that? How do we determine what was the intent? I didn't intend to enter that agreement. What if we agreed? You indicated that we agreed that I was going to shovel your driveway and you were going to pay me $20, and then I said no, I didn't agree to that. When you asked me to shovel your driveway, no, I didn't agree to that. How does a court determine whether agreement was actually entered? That is the question. Is that based on what I think? Is it based on what you think? What do we look at? Some of the things that a court will look at, first of all, is not what the subjective view of a person, a part of the contract is. So if I say, yeah, I didn't agree to that, okay, you're saying you didn't agree to that, but let's look at kind of what happened. And some of the things that a court will look at based on what an objective person would think under the circumstances, maybe what the parties said when entering into the contract. How did the parties act, or how did they appear? What were the circumstances surrounding the transaction? So back to the shoveling snow example. It's July and you ask me to shovel snow and you're going to pay me $20, and you're going to be out of town. You need someone to shovel your driveway in the wintertime, and I'm going to shovel and you're going to pay me $20 a time to do that. And it gets to be December and we have our first snowstorm, and I don't shovel your driveway, and your neighbor calls you, your driveway's not shoveled, and then you call me. I said, I didn't agree to that. And then you sue me. These are the things that a court's going to look at. What the party said when we were entering, how I behaved or acted, and what were the circumstances surrounding the transaction. Now, if we were out in July and we were having some drinks, and you asked me to shovel a driveway for $20, and I start laughing, I'm like, yeah, sure, I'll shovel your driveway for $20. That's going to be something that they consider. Was I just joking around, or was I serious? So those are the things that are going to be looked at by the court. Okay, so those are the things we would look for. Accountability for conduct that induces reasonable reliance. That's the goal. That's the goal of contract law. Accountability for conduct that induces reasonable reliance is the vital goal of contract law. So if you reasonably relied on me shoveling your snow and the circumstances surrounding that, or parties' conduct, then it will be determined that I could be liable for a breach of contract. So, all right, now, quick example. Maggie Zine owns a newsstand. She needed to visit the dentist one morning. On the night before her dentist appointment, she asks her brother to attend the newsstand for her. He agreed if she paid him $50 in advance. Maggie pays brother $50 in cash in advance. Did they enter into a contract that evening? consider. Did they enter a contract evening? Why or why not? I would say that they did. If we use the objective person standard, what would a reasonable person under the circumstances conclude? Did Maggie rely on her brother? Well, she paid him $50 in advance, so she intended that he would be attending the newsstand the next morning. In my example, it doesn't say that he didn't show up or not show up. I'm just establishing, reviewing these circumstances. Would you think that they entered into a contract? The answer would be yes. Because Maggie reasonably, based on the circumstances, Maggie would have reasonably relied on her brother's comments to her and her actual payment of the $50. Consider this example. This example is part of the forum post 1, so I'm not going to discuss it, but consider this example based on what we just discussed when considering your answer relative to the forum post for this week. So, basic requirements of a contract. All contracts must have these requirements, and we will break these down into their own specific topics as we move through the next couple days of classes on this. But these all must exist. There must be an agreement, there must be an offer made and an acceptance, and we'll talk about those specifically, what those mean. There must be consideration involved, meaning something of value is received or promised to convince a person to make a deal. Capacity. Both parties must have capacity, meaning the law recognizes them as possessing characteristics that qualify them as competent parties. Consider minors and their ability to enter into contracts, and like I said, we'll break these down and talk about them in their specific details as we move forward. And legality. Contract's purpose must be to accomplish some goal that is legal and not against public policy. So these 4 things must exist. However, I will note that even if those things exist, there could be a situation where the contract may not be enforceable, despite those 4 requirements being met. And in those circumstances, consent in proper form. Voluntary consent. There must be voluntary consent. If you enter into a contract under duress, fraud, or mistake, or something else, you haven't consented. You have to have you must have a voluntary agreement between 2 people, oral or written. And form. Sometimes there's specific contracts that need to be in a certain form. The law requires them to be in certain form, and if they're not, there is no contract. Okay? So again, this is just an intro to all of these concepts that relate to common law and the sales contracts under Article 2. So this is a general overview, and we're going to break those down as we go along. Okay, let's talk about the different types of contracts. And I don't mean sales contracts, common law contracts. Under both of those umbrellas, they have types of contracts that exist, okay, by law. Our first one we're going to talk about is bilateral versus unilateral contracts, and that's going to depend. Well, let me back up here. So you need at least 2 parties to a contract, okay? It starts with someone making an offer. They just don't appear. Contracts just don't appear. It takes one person to extend an offer. We call that person an offerer. The party receiving the offer, or to who the offer is made, that person is called the offeree. The offerer is also the one making the promise to do or not to do something. Okay, so this is going to depend, our contract, the determination of whether a contract's bilateral or unilateral is going to depend on what the offeree has to do to accept the offer and bind the offerer to the contract. Okay? So whether a contract is bilateral. And this is what most contracts are, bilateral. So to determine whether a contract's bilateral or unilateral depends on, as I said, what the offerer has to do to accept the offer and to bind the offerer to the contract. If to accept the offer, all the offeree must do is promise to do something, promise to perform, promise for a promise, nothing needs to happen, that is a bilateral contract. That's our shoveling snow example. I agree to shovel your snow. I promise to shovel your snow. You promise to pay me $20. That's a bilateral contract. And that's what most contracts are. Okay? I offer to, how about this example? Oh, I don't have it on here. How about this example? I offer to sell you my car for $1,000. If you wish to accept this offer, I'm the offerer. I offer to sell you my car for $1,000. If you wish to accept this offer, you must stand dressed like the Grinch on the corner of Cornelia and Beekman Street today at 2 o'clock. You go out to the corner at 2 o'clock dressed like the Grinch. Did you accept the offer? Yes, you did. You don't have to tell me. It's by your conduct. No words required. That is a bilateral contract. So, a unilateral contract is a promise for an act. What does that mean? If the offer is phrased so that the offeree can only accept by completing the contract performance, then we have a unilateral contract. Okay? When is the contract formed? At the time of performance. Types of examples of unilateral contracts are contests, lotteries, competitions for prizes. A person must comply with all the rules. Once done, they're binding the organization that's offering the prize to the contract. That's where you see those most commonly. But problems arise. Consider this example. Margot offers to buy Harry's sailboat, which is moored in California. The offer is to buy the boat moored in California on delivery to Mystic, Connecticut at Margot's dock. Harry rigs up the boat, sets sail. Right before he arrives, Margot calls him and changes her mind, withdrawing the offer. What do we have here? Do we have a problem? What happens? Is there an issue at all? If it's a unilateral contract, Harry can only accept upon full performance. But he started delivering there. He just didn't get to Mystic, Connecticut, which would have been full performance. You see any unfairness there? Usually offers are revocable. In this instance, though, the modern view is that an offer is not revocable if performance has been undertaken. As you can see, there's some bit of unfairness here. If Harry's almost to Mystic, Connecticut, and Margot changes her mind, right? We'll talk more about this instance when this comes along and the rights that a person has when that happens. But for the most part, if performance has been undertaken, then Margot has to comply fully with the rest of the obligation. The next set of contracts we have express versus implied, and that's kind of just what they suggest, right? What it implies. If you have an express contract, we have a contract where the terms of the agreement are fully and explicitly stated. Consider, for example, Katie and Laura. They're talking to each other on FaceTime. During the conversation, Katie agrees to buy Laura's MacBook computer for $750 on the first day of the following month. Is that an express contract? What are the terms? The terms are fully expressed there. Katie's going to buy the MacBook for $750 on the first day of the following month. That would be an example of an expressed contract. Consider an implied contract. What's an implied contract? It's the conduct of the parties that dictates or creates the contract. So consider that example. Joe needs a lawyer to draft a will. Joe meets with Attorney Smith, explains the situation, learns Attorney Smith's fees, and leaves. Joe comes back the next day and drops off the list of people he wants in his will, and he leaves. Attorney Smith drafts the will, sends it to Joe. Do we have a contract? Does Joe owe the fee? What do we have to consider? Sounds like a contract, but nobody specifically said this is the contract. No one expressly stated what the terms were. This is what we consider. Whether the party furnished goods and services. Was there goods and services furnished? Yep. The attorney drafted the will. Do we have a party expects to get paid for goods and services? I would think so. You show up at a law firm and tell them you need a will done and explain the circumstances. I would believe that the attorney expected to be paid. And the party receiving the goods, Joe in this case, do you think he should know that payment is expected? Well, he went and he met with an attorney and he learned about the fees. And number 3, is there an opportunity for Joe to reject them? It doesn't say in the example, but the will was already done. What if Joe came back and decided to pick up his paperwork before the will was drafted? But then the will was drafted after the fact. Maybe not. But in this case, Joe would have to owe the fee based on the circumstances. And again, what's the review? The objective standard. What a court would look at. Not what Joe would think, not what the attorney would think. Based on the circumstances, what would a reasonable person under the circumstances think? In creating a implied contract, which is based on the parties' conduct that dictates whether or not one was created. Next type of contract that we have is something called a quasi contract. Kind of, sort of a contract. It's not really a true contract. They don't arise from any agreement between parties. So what are they? It's a contract that is imposed on parties out of fairness. It's a contract, quote unquote, implied by law. The goal of this is to, let me consider this example, okay? Freshwater Services operates a water distribution system that services a residential area, including Joe and Carol Green's home. The Greens do not have an express contract with Freshwater, but the couple pays the firm's monthly charges for water. When Freshwater increases the monthly price, Greens refuse to pay more. Freshwater files suit to collect the additional charges. Will they win? Well, there's not a express contract here. There's not necessarily an implied contract here based on the 3 requirements that we look for to determine whether or not there is a implied contract. But we have a couple that lives in an area where water is furnished. Consider if you live in the city of Plattsburgh. I live in the city of Plattsburgh, and I have to pay a water bill every month or so. Even if I don't use the water, if I decide I ain't touching the city water, I'm going to have all my own water brought in bottles and so forth. They provide a service to me. It is here. It's part of living in the city. This is the same sort of situation. So, do the Greens have an express contract? No. But when the fees go up and the Greens refuse to pay, they're still using, in this instance, they're using the water. So, do you think Freshwater should be able to collect for their additional charges? under a quasi contract imposed on them by law out of fairness. The goal, if you think about it in that instance, is to prevent unjust enrichment of one party at the expense of another. The greens are getting water, and the fresh water is paying for extra expenses as to why the price went up. Would they be unjustly enriched, the greens, in this case? Sure. What the person who conferred the benefit, the unjust enrichment is what the person who conferred the benefit can claim under unfair circumstances. So freshwater can claim the extra additional fees because the greens are conferring a benefit to the greens. So, and not being able to collect would be unfair. So that's a quasi-contract. The court imposes a contract by law. Consider, I think I have another example here. Yeah, consider this example. Rhonda leaves her car at the dealer for oil change and a lube service. When she picks up her car, she learns that mistakenly, the dealer performed a coolant fluid service in addition to oil and the lube job. This is a quasi-contract. Should a quasi-contract be imposed here? Why or why not? Would the dealer be unjustly enriched? No. They would not be unjustly enriched. I mean, they may have conferred a benefit to Rhonda, but Rhonda dropped her car off for an oil and lube job and, unexpectedly got a coolant and fluid service. While she got a benefit, it wasn't a benefit that she sought or was going to use. Compare that to the freshwater company. It's not like the freshwater company could cut off the greens from paying for water. Do you see the difference in this example? Unfortunately, this was a mistake. This was a mistake made by the dealer, and the dealer would unfortunately have to swallow the costs involved. There's no unjust enrichment here. A court would not impose a quasi-contract due to unfairness. This was a mistake, and it wasn't something that Rhonda had sought. So that's her quasi-contract. And then we have formal and informal contracts. These are, again, this is fairly straightforward. Formal contract, and we'll delve into these a little bit more in the semester, are going to be contracts that require a special form or a special method for creation to be enforceable. Things like checks. Checks have to be made in a certain form for them to be enforceable. Notes, like a mortgage note. Letters of credit, certificates of deposit. Those are things that are considered formal contracts and need a specific form. All other contracts are informal, and that's the distinction. And we have executed contracts and executory contracts. And this is going to depend on the state of the performance, where we are with regards to this contract. So we have this contract, shoveling snow, right? You are paying me $20 to shovel snow each time I have to shovel snow. Okay? So that's our contract. We have an executed contract if I come and I shovel the snow and you pay me $20. That is an executed contract. It is completed. It's fully performed on both sides. I come out, I shovel, I'm done. You come out, look at it, you pay me my $20. Executory contract is when only one side has been fully completed and fully performed. I come over, I shovel your driveway, and it's Wednesday, and you're going to pay me on Friday when you get paid. So I've done my part. I've shoveled the driveway, and now you have to pay me if the contract's in that state where one side has only been performed, that's considered an executory contract. So, executed, fully performed, completed, executory, not fully performed, but one side has performed. Then we have contracts, valid, voidable, unenforceable, and void. And kind of an oxymoron, void contracts. If it's void, you have no contract. But that's how this is going to lay out. So valid contract, straightforward. If you have a valid contract, it has all the necessary requirements that entitles one of the parties to enforce in court. Done. Valid contract. We have a valid contract. I shovel snow and you pay me. Valid contract. Voidable contract. These are valid contracts, but because they're valid contracts because they have all the necessary requirements. Okay, they meet all of those four requirements. However, they could be deemed voidable by one of the parties because maybe one of the parties is a minor, or maybe a party had entered into the contract under duress or fraud or mistake or undue influence. If any of those exist, the party who is maybe the minor or the one that feels like they're under duress, they can avoid their duty to perform and be released from their duty. So if you enter into a contract with a 13-year-old and the 13-year-old says, nope, I'm out, that you cannot enforce, that contract cannot be enforced. It's voidable. It may very well have been a valid contract meeting all the four requirements, but because of a legality issue, i.e. the child is minor, or the person you entered into the contract with is a minor, then they're going to release their duty and you would not be able to sue them. I will note, however, despite that, the person who is maybe the minor in this instance, or who may have entered in the contract under duress, they can, quote unquote, what's called ratify, or then make it valid. And then they must perform. We are going to go through this in very specific detail when we get to this part of the lecture a couple days from now. Again, we're just kind of doing an overview. All right, consider unenforceable contracts. Again, valid contract, it may meet all of the four requirements, but the law says it's unenforceable. An example of that may be, I agree to sell you my house for $100,000. You come with a check to buy it. I change my mind. Yeah, no, it's worth more than that. I'm not going to sell it to you. And you try and sue me. You will learn when we talk about form that all contracts for the sale of real property must be in writing. So if this is not in writing, the court is going to deem it unenforceable. It's a valid contract, but it's rendered unenforceable by law. In this state, in this example, certain contracts must be in writing, i.e. real estate. So if we don't have that agreement in writing, then you're not going to be able to sue me because the law is going to render it unenforceable. Void, no valid contract. There's no legal obligation on any of the parties. It's a void. Molly, here's an example. Molly tells Rick that she will pay him $10,000 to set fire to her store so that she can collect the money from her fire insurance policy. Nick sets fire to the store, but Molly refused to pay him $10,000. Can Nick recover from Molly? Why or why not? Is this a valid contract? Sure, it meets all the four requirements. However, it's going to be void because it's illegal to set fire to a store. So in this case, this contract will be deemed void. There's no valid contract, so Molly does not have to pay Nick. Nick might get arrested for arson, but in this example, the contract is void. E-contracts, I'm sure you've seen those contracts that you enter into online, buying things on Amazon.com. We are going to explore this a little more. Contracts online are governed by the Uniform Electronic Transaction Act. That doesn't mean that means that it's guided by how things enter into form. It doesn't mean that it involves the Uniform Commercial Code, which is a transaction for sales. This is things like an e-signature, what types of rules have to be in the actual guidance or the structure of the contract, such as, and I'll show you an Amazon.com transaction contract that's governed by the Uniform Electronic Transaction Act. But we're not going to be tested on that. That doesn't tell us how contracts works. That's just how the form of things have to happen. So these are contracts that are entered online. And then our overall interpretation of contracts: when there is a contract dispute, a party sues and a court must interpret the contract terms. Are the terms clear or are the terms ambiguous? What is in... actually, let me back up a second. So are the terms clear or are they ambiguous? A party sues. We have a breach of contract. I agree to shovel snow on your driveway. You agree to pay me $20. Is that clear? Or can that be interpreted in a different way? If the terms are clear, the court is going to enforce the contract pursuant to the plain meaning rule. No other evidence is going to be considered outside the contract or the document itself. If the court can read the contract or understand the contract, I don't want to say read because contracts don't always have to be written. If the court can understand the concept of the contract, it is going to remain within the plain meaning of what it understands it to be. It's not going to consider anything else. Okay? So what is in a contract is going to determine what the party's intent is at the time they entered into the contract. So if you're going to buy a house, what are you going to want to know? What's the address? What's the price? What's the down payment? What's the closing date? So the more terms that you can lay out, certainly the clearer your contract becomes. But we're going to learn when we talk about forms of contract, we don't need every single specific little detail. But what if we have terms that are ambiguous or there's a dispute over a point that's not in a contract? Consider this. Lisa and Daryl Miller had a son, Landon. When the Millers divorced, they entered into a joint plan. Under the plan, Daryl agreed to, quote unquote, begin setting funds aside for Landon to attend college. Lisa asked the court to order Daryl to pay the boy's college expenses based on the plan. Daryl contended that the plan was not clear on this point. So what do we have? What do we have here? We got agreed to begin setting funds aside for Landon to attend college. Is that clear? Does that mean that Daryl has to pay the boy's college expenses? It's kind of ambiguous. First rule of thought on court interpretation is the court is going to interpret any ambiguous terms or contract against the drafter. So if you're the drafter of the contract and this is your contract and you draft it up, you already got one kind of shot against you. Other things the court's going to consider: what is the intent of the parties from the language? Does the contract have a provision on a disputed issue? Can a contract term be interpreted in more than one way? Is there any uncertainty about a particular provision? What type of evidence would the court want to hear? So in this instance, back to Lisa and Daryl Miller, we can agree that the term begin setting funds aside for Landon to attend college is ambiguous. We don't know if that means that they intended that Daryl pay for all of the college expenses. So what would the court want to hear? More testimony from the parties. Maybe there were notes and emails at the time that was written into, that provision came about that was exchanged. And those are the things the court is going to have to look at to determine the rules of contract interpretation to support whether it's going to be Lisa's request or Daryl's contention that ultimately rules. So these are the things that a court looks at when they're dealing with an ambiguous contract. So maybe the key is to be as specific as possible, but you're going to see as we go along that that is not always the case. So one last overall example here before we delve into the specifics of each one of these requirements. Jack, Barry, and Simone are visiting San Francisco during spring break. Jack offers to pay Simone $100 if she walks across the entire span of the Golden Gate Bridge. So consider this. If Simone says nothing but simply walks across the bridge, do she and Jack have a contract? And what type of contract do they have? Well, they do have a contract, and because she simply walks across the bridge, that's a unilateral contract. Performance. She has to walk across the entire span of Golden Gate Bridge, so it's a unilateral contract. So what if she walks halfway across the bridge and Jack changes his mind and says, "Oh, I changed my mind"? Normally, full performance is the requirement for acceptance, but as I indicated under the modern review, because she has started performance, she's entitled to complete performance. Now, if she gets halfway across and changes her mind that I ain't kind of go all the way, I'm too tired, and comes back, well, then there's no agreement. If Jack offers to pay Simone $100 if she walks across the entire span of the Golden Gate Bridge, and Simone says, "Oh, no, I'm not going to do that," and turns around and walks away, are there any legal consequences? No, because it was just an offer and she didn't accept. She didn't act. You need the promise to act, or you actually have to do it. So there's no contract. What if, without saying a word, Barry, rather than Simone, starts to walk across the bridge? Do Jack and Barry have a contract? No, they don't. Why? Because the offer was made to Simone. Only the person to whom offer is made can accept. So Barry, if he made it all the way across, would not be able to collect the $100 from Jack. So that ends the introduction to contracts. We will begin offer acceptance and consideration next time, and review the Form 1 question and post, and we'll see you next time.